I already covered how Min Hee-jin just won her put option lawsuit between her and HYBE, and though HYBE has said they are going to appeal, this seems to put Min in a stronger position, and a lot of reporting suggests that might be true. So I'm going to cover specifically how this may affect the 43 billion damages lawsuit, which is the one that names not just Min Hee-jin, but also Danielle from NewJeans and a family member of Danielle's. And I'm getting a lot of this reporting from the Korea Herald, Insult, and Top Star News. So first, it's important to understand the case that Min just won. So HYBE argued that it had the right to terminate its shareholder agreement because they alleged that Min tried to separate ADOR from HYBE, damaged the company's reputation, and undermined internal trust. And while the court acknowledged she explored independence, it ruled that this did not amount to a serious contractual breach, and most importantly, the judges did not find proof that her actions caused measurable harm to ADOR's growth. And that finding is critical. In particular, it's what strengthens Min's leverage going forward, because the court has signaled something very important: allegations alone aren't enough. If reputational damage and internal conflict weren't serious enough to terminate a shareholder agreement, then proving massive financial damages becomes harder, not easier, especially since the damages case reportedly relies on overlapping themes like disruption, harm, and interference. And to fill you in on the damages lawsuit by ADOR, which is seeking a 43 billion won from Min Hee-jin, Danielle, and one of her family members, according to the very limited reporting we have now, because no direct claims have been really made, what's been alleged is that there was disruption of group activities, reputational harm, financial losses, and possible interference with contractual relationships. Again, all speculative, and we hope to know more soon. But again, unlike the put option case, this one is about alleged monetary harm. So to succeed, ADOR would need to show that specific actions directly cause specific financial losses. And large numbers, like they are claiming damages for, requires very concrete proof. I want to clarify something that I was curious about, because Min's position being stronger doesn't automatically make Danielle's position stronger. Her legal position is not identical to Min's. Min was evaluated as an executive and shareholder, and Danielle would be evaluated under her exclusive artist contract. So while the skepticism from the court about corporate harm may weaken the overall damages narrative, it does not automatically resolve Danielle's own exposure. And if ADOR argues that she breached her contract or participated in unauthorized activities, again, not saying she has or anything like that, that analysis, though, would be separate from whether Min committed a serious shareholder violation. And I was curious about how damages might be divided, and reportedly, because multiple defendants are named, the court could assign responsibility in percentages or hold them all jointly responsible. But either way, the 43 billion is the amount being claimed, not necessarily what would be awarded, and large claims are often strategic and final judgments can be significantly lower.